What's up, y'all? You're watching Union Minded. I'm your host, Eric, and today we are getting back to the LMRDA of 1959. Yesterday's video, we had a little fun talking about shop rocketism. Lots of debate going on about shop rocketism, but we're not here for that. Today we're talking Title IV. It's a very important title because it covers elections, and it's very important particularly right now because my local 26, just went through an election that ended up so depressing and so counter to what I feel the general temperature of the body politic was, that I don't feel real good about this election. It just feels foul. And if you are a member of Local 26 who's active, you'll remember last election cycle, something similar happened. The challengers lost 70-30, and the temperature was bad because we had just had a bad contract where in that contract was negotiated a daggum stipulation that limited the amount of PTO we would be able to get if a state passed a law that was better than the PTO that was bargained for. So it really kind of locked us in at whatever PTO was able to be negotiated for, in spite of better PTO existing in law around us. So it felt bad. But anyway, that's besides the point, because we're talking elections, and this is broader than 26. This is federal law. It covers every local. So here we go. Terms of office and election procedures. We start with section 401. Every national or international labor organization, except for Federation of National or International Labor Organizations, shall elect its officers not less often than once every 5 years, either by secret ballot among the members, that would be sort of like one member, one vote, or at a convention of delegates chosen by secret ballot, which is what the IBEW does. Every local labor organization, by the way, support one member, one vote. Every labor organization shall elect its officers not less often than once every 3 years by secret ballot amongst the members in good standing. So the international, every 5 years, we do it at convention, hashtag one member, one vote. And every local does it every 3 years, okay, by secret ballot. C, every national or international labor organization except the Federation of National or International Labor Organizations, and every local labor organization and its officers shall be under a duty enforceable at the suit of any bona fide candidate for office in such labor organization in the District Court of the United States in which such labor organization maintains its principal office, to comply with all reasonable requests of any candidate to distribute by mail or otherwise at the candidate's expense literature in aid of such person's candidacy to all members in good standing of such labor organization, and to refrain from discrimination in favor of or against any candidate with respect to the use of lists of members, and whenever such labor organizations or its officers authorize the distribution by mail or otherwise to members of campaign literature on behalf of any candidate or of the labor organization itself with reference to such election, similar distribution at the request of any other bona fide candidate shall be made by such labor organization and its officers with equal treatment as to the expense of such distribution. That's a lot of words to basically say that every labor organization has to mail out campaign lit at the candidate's expense. I do wonder how that pertains to re-election campaigns when the salaries of said officers is paid by the dues of the members. So kind of by default, it's dues paying members money. So when they run together and then send out literature of their campaign as a slate, and it's all the same officers that are in office, I wonder how that would apply. It's a curious. I'm no lawyer. It's just an interesting question. But one I would argue that if you send out a mass pamphlet, an election pamphlet with all of your guys that are running on your slate, and you're all officers of the local, I would think you would need to offer the same type of mailing for your opposition. But that's just me. And again, I'm a dumb electrician. What the heck do I know? But let's keep reading. Every bona fide candidate shall have the right, once within 30 days prior to an election of a labor organization in which he is a candidate, to inspect a list containing the names and last known addresses of all members of the labor organization who are subject to a collective bargaining agreement requiring membership therein as a condition of employment, which list shall be maintained and kept at the principal office of such labor organization by a designated official thereof. Adequate safeguards to ensure a fair election shall be provided, including the right of any candidate to have an observer at the polls and at the counting of the ballots, which is normal. That happens every election, where you can have somebody there to watch the process and observe. D, officers of intermediate bodies such as general committees, systems boards, joint boards, or joint councils shall be elected not less often than once every 4 years by secret ballot among the members in good standing, or by labor organization officers representative of such members who have been elected by secret ballot. Letter E, in any election required by this section which is to be held by secret ballot, a reasonable opportunity shall be given for the nomination of candidates, and every member in good standing shall be eligible to be a candidate and to hold office subject to section 504 and to reasonable qualifications uniformly imposed, and shall have the right to vote for or otherwise support the candidate or candidates of his choice without being subject to penalty, discipline, or improper interference or reprisal of any kind by such organization or any member thereof. Not less than 15 days prior to the election, notice thereof shall be mailed to each member at his last known home address. Each member in good standing shall be entitled to 1 vote. No member whose dues have been withheld by his employer for payment to such organization pursuant to his voluntary authorization provided for in a collective bargaining agreement shall be declared ineligible to vote or be a candidate for office in such organization by reason of alleged delay or default in the payment of dues. So that means if your company hasn't been on their ball of getting the money to the local, you can't be held responsible for that. The votes cast by members of each local labor organization shall be counted, and the results published separately. The election officials designated in the Constitution and bylaws of the Secretary in no other official, let me read that again. The election officials designated in the Constitution and bylaws, or by the Secretary, if no other official is designated, shall preserve for 1 year the ballots and all other records pertaining to the election. The election shall be conducted in accordance with the Constitution and bylaws of such organization insofar as they are not inconsistent with the provisions of this title, which means this title supersedes the Constitution and the bylaws. So if they're not doing at least this supersedes it. F, when officers are chosen by a convention of delegates elected by secret ballot, the convention shall be conducted in accordance with the Constitution and bylaws of the labor organization insofar as they are not inconsistent with the provisions of this title. Again, this title supersedes our Constitution and our bylaws. The officials designated in the Constitution and bylaws, or the Secretary, if no other is designated, shall preserve for 1 year the credentials of the delegates and all minutes and other records of the convention pertaining to the election of officers. G, no monies received by any labor organization by way of dues, assessment, or similar levy, and no monies of an employer shall be contributed or applied to promote the candidacy of any person in an election subject to the provisions of this title. Such monies of a labor organization may be utilized for notices, factual statements of issues not involving candidates, and other expenses necessary for the holding of an election. H, if the Secretary, upon application of any member of a local labor organization, finds, after hearing in accordance with the Administrative Procedure Act, that the Constitution and bylaws of such labor organization do not provide an adequate procedure for the removal of an elected officer guilty of serious misconduct, such officer may be removed for cause shown and after notice and hearing by the members in good standing, voting in a secret ballot conducted by the officers of such labor organization in accordance with its Constitution and bylaws, insofar as they are not inconsistent with the provisions of this title. They keep on restating that it can't be inconsistent with the provisions of this title. That's why I keep saying it's important that you guys read this and learn it and understand it, because it applies to you and your membership in a union. The secretary shall promulgate rules and regulations prescribing minimum standards and procedures for determining the adequacy of the removal procedures to which reference is made in subsection H. Now we get to the enforcement of this set of rules for electioning, right? For the election, the running of an election. Enforcement. This is section 402. A member of a labor organization, 1, who has exhausted the remedies available under the Constitution and bylaws of such organization and of any parent body, or 2, who has invoked such available remedies without obtaining a final decision within 3 calendar months after their invocation, may file a complaint with the secretary within 1 calendar month thereafter alleging the violation of any provision of section 401, including violation of the Constitution and bylaws of the labor organization pertaining to the election and removal of officers. The challenged election shall be presumed valid pending a final decision thereof, as hereinafter provided. And in the interim, the affairs of the organization shall be conducted by the officers elected or in such other manner as its constitution and bylaws may provide. So if someone does file a claim or whatever challenges an election, the election is going to stand during the investigation so that business can proceed as normal, is what this part is saying. B, the secretary shall investigate such complaint, and if he finds probable cause to believe that a violation of this title has occurred and has not been remedied, he shall, within 60 days after the filing of such complaint, bring a civil action against the labor organization as an entity in the District Court of the United States in which such labor organization maintains its principal office, to set aside the invalid election, if any, and to direct the conduct of an election or hearing and vote upon the removal of officers under the supervision of the secretary and in accordance with the provisions of this title and such rules and regulations as the secretary may prescribe. Now remember, on the previous videos when I told you they keep referencing the secretary, they're talking about the Secretary of Labor. It's not just that's the Secretary of Labor. That's the federal government, you know what I'm saying? The court shall have power to take such action as it deems proper to preserve the assets of the labor organization. Letter C. If upon a preponderance of the evidence and after a trial upon the merits, the court finds, 1, that an election has not been held within the time prescribed by section 401, or 2, that the violation of section 401 may have affected the outcome of an election, the court shall declare the election, if any, to be void and direct the conduct of a new election under the supervision of the secretary, and so far as lawful and practicable in conformity with the Constitution and bylaws of the labor organization. The secretary shall promptly certify to the court the names of the persons elected, and the court shall thereupon enter a decree declaring such persons to be the officers of the labor organization. If the proceeding is for the removal of officers pursuant to subsection H of section 401, the secretary shall certify the results of the vote, and the court shall enter a decree declaring whether such persons have been removed as officers of the labor organization. Letter D. An order directing an election, dismissing a complaint, or designating elected officers of a labor organization shall be appealable in the same manner as the final judgment in a civil action, but an order directing an election shall not be stayed pending the appeal. That means even though if they find that there was a problem and they order a new election or whatever, or removal of officers, that decision can be appealed, but it's not going to keep the process from moving forward, just the same as a challenge to an election won't stop the process of the moving forward with the officers. You know what I mean? In other words, business is going to continue because business has to keep continuing because we have members that need to have representation. All right. Application of other laws. This is section 403. No labor organization shall be required by law to conduct elections of officers with greater frequency or in any different form or manner than is required by its own constitution or bylaws, except as otherwise provided by this title, existing rights and remedies to enforce the Constitution and bylaws of a labor organization with respect to elections prior to the conduct thereof shall not be affected by the provisions of this title. The remedy provided by this title for challenging an election already conducted shall be exclusive. Now we're talking effective date. This is section 404. Now remember, this law was passed in 1959. It's effective. The provisions of this title shall become applicable 90 days after the date of enactment of this act. So I mean, you get it. The next title will go safeguards for labor organizations. That's going to be the next video. This one's already been 15 minutes. It's plenty long. But I'm trying to, bring you guys some information that maybe doesn't come across your desk, doesn't come across your toolbox. You know what I'm saying? And so I want to bring you stuff that interests me, because I focus on growing the brotherhood, the siblinghood, the membership involvement, and the solidarity amongst labor organizations, IBEW members, Local 26 members especially, because that's where I'm out of, and I'm just trying to do the best that I can. So read it for yourself. It's easy to find on the internet. Just look up the LMRDA 1959. All right, and please keep in mind that the fight is not left and right. It never has been. We've been fooled. The fight is up and down. That's where it's always been. Check your labor history and you'll know the fight is up and down. And it's going to take solidarity to win. If we don't have solidarity, we can't win. That's what I got for you. Don't forget to like, hit the subscribe button, notification bells, and share these videos. And remember, each one teach one. So get out there and reach one. All right, peace.